Hey everyone, welcome to KSSP Podcast. I'm Spencer,
And I'm Katie.
and today we're going to be talking about privacy.
Yes. So we're going to start with an ACLU article about the NSA. So, all right. The National Security Agency's mass surveillance has greatly expanded in the years since September 11th of 2001. Disclosures have shown that until recently, the government regularly tracked the calls of hundreds of millions of Americans. Today, it continues to spy on vast but unknown number of Americans' international calls, text messages, web browsing activities, and emails. What was this? Did it say when this was written? No. Okay, that's fine. The government surveillance programs have infiltrated most of the communications technology we've come to rely on. They are largely enabled by a problematic law passed by Congress, the FISA Amendments Act, which is set to expire this year, along with Executive Order 12333, the primary authority invoked by the NSA to conduct surveillance outside the U.S. The Patriot Act has also made it easier for the government to spy on Americans right here at home over the past 15 years. Although the Foreign Intelligence Surveillance Court oversees some of the government's surveillance activities, it operates in near total secrecy through one-sided procedures that heavily favor the government. Our Constitution and democratic system demand that government be transparent and accountable to the people, not the other way around. History has shown that powerful secret surveillance tools will almost always certainly be abused for political ends. The ACLU has been at the forefront of the struggle to rein in the surveillance superstructure that strikes at the core of our rights to privacy, free speech, and association. Surveillance under the FISA Amendments Act. The FISA Amendments Act of 2008 gives the NSA almost unchecked power to monitor Americans' international phone calls, text messages, and emails under the guise of targeting foreigners abroad. The ACLU has warned that one provision of the statute, Section 702, would be used to eavesdrop on American private communications. In June 2013, The Guardian published documents provided by whistleblower Edward Snowden confirming the massive scale of this international dragnet. Recent disclosures also show that an unknown number of purely domestic communications are monitored, that the rules that supposedly protect Americans' privacy are weak and riddled with exceptions, and that virtually every email that goes in or out of the U.S. is scanned for suspicious keywords. In 2008, less than an hour after President Bush signed the FAA into law, the ACLU filed a lawsuit challenging its constitutionality. The case Amnesty v. Clapper was filed on behalf of a broad coalition of attorneys and orgs whose work required them to engage in sensitive and sometimes privileged telephone and email communications with individuals located abroad. But in a 5-4 ruling handed down in February 2013, the Supreme Court held that the ACLU plaintiffs did not have standing to sue because they could not prove their communications had actually been surveilled under the law. So in March, the ACLU filed Wikimedia Foundation versus NSA, a lawsuit challenging upstream surveillance under the FAA. Through upstream surveillance, the U.S. government copies and searches the contents of almost all international and many domestic text-based internet communications. The suit was brought on behalf of 9 educational, legal, human rights, and media organizations, including the Wikimedia Foundation, operator of one of the most visited websites on the internet. Collectively, the plaintiffs engage in more than a trillion sensitive internet communications every year, and each has been profoundly harmed by NSA surveillance. So, surveillance under the Executive Order 12333. So this executive order, signed by Reagan in 1981 and modified many times since, is the authority primarily relied upon by intelligence agencies to gather foreign intelligence outside the U.S. So recent disclosures indicate that the U.S. government operates a host of large-scale programs under this executive order, many of which appear to involve the collection of vast quantities of Americans' info. These programs have included, for example, the NSA's collection of billions of cell phone location records each day, its recording of every single cell phone call into, out of, and within at least 2 countries, and its surreptitious interception of data from Google and Yahoo user accounts as information travels between those companies' data centers located abroad. The ACLU, along with Media Freedom Info Access Clinic at Yale Law School filed Freedom of Information Act lawsuit demanding the government release info about its use of this executive order to conduct surveillance of Americans' communication. So, the Patriot Act. For many years, the government claimed sweeping authority under the Patriot Act to collect a record of every single phone call made by every single American on an ongoing daily basis. This program not only exceeded the authority given to the government by Congress, but it violated the right of privacy protected by the Fourth Amendment and the rights of free speech and association protected by the First Amendment. For this reason, the ACLU challenged government records collection of our phone records under Section 215 of the Patriot Act just days after the program was revealed by The Guardian. In May 2015, a court of appeals found that the phone records program violated Section 215 and Congress allowed provision to expire in June of that year. The program was reformed by the USA Freedom Act, which passed days later. To bring greater transparency to the NSA surveillance, the ACLU filed 2 motions with the secretive FISC asking it to release the public its opinions authorizing the bulk collection of Americans' data by the NSA. Our earlier work to reform Patriot Act includes a number of successful challenges to the government's use and secrecy surrounding national security letters. So bringing transparency to the FISA court. So the ACLU long fought to bring greater transparency and public access to the FISC, the secretive court that oversees the government's surveillance programs. When the FISC was first established in 1978, it was primarily assessed individual surveillance applications to determine whether there's probable cause to believe a specific surveillance target was an agent or of a foreign power. In recent years, however, the FISC's responsibility have changed dramatically, and the FISC today oversees sweeping surveillance programs and assess their constitutionality, all without any public participation or review. So they've been advocating and petitioning for access to the FISC for more than a decade, working with Congress and the executive branch and appearing before the court itself to push for greater transparency. Days after the court's Section 215 order was published in the press in June 2013, we filed a motion seeking access to the judicial opinions underlying the NSA's Max Call Tracking Program. We have since filed 2 other access motions in the FISC seeking significant legal opinions, authorizing bulk collection of those interpreting the government's secret surveillance powers in the years after 9/11. We also signed a brief on the FISC support of the First Amendment rights of the recipients of FISC orders, such as telephone and internet companies, to release info about the type of volume of national security requests they receive from NSA and the FBI. So secret law has no place in democracy. Under the First Amendment, the public has qualified right of access to FISC opinions concerning the scope, meaning, or constitutionality of the surveillance laws, and that right clearly applies to legal opinions interpreting Americans' bedrock constitutional rights. We all have a right to know, at least in general terms, what kind of info the government is collecting about innocent Americans, on what scale, and based on what legal theory. So basically, there's no transparency in what kind of data they're collecting from us.
Okay.
So
I also would be interested to see if it's even helped, because obviously they're claiming that they do this to protect America, but have they prevented any terrorist attacks by collecting this information from us?
Right.
Because if they haven't, then to me that means that legally they shouldn't be able to anymore then, because it hasn't prevented anything. I don't know if it has, but if it hasn't, then like I feel like I remember somewhere saying that it doesn't help stop terrorists, but I don't remember.
Let's see. So what's the evidence mass surveillance works? Not much. So let's see. The FBI General Counsel defined as useful those leads that made a substantive contribution to identifying a terrorist or a potential confidential informant. Just 1.2% of them fit that category. In 2006, she conducted a comprehensive study of all the leads generated from the content basket of stellar one between March, and discovered that 0 of those had been useful. The program was generating numerous tips to the FBI about suspicious phone numbers and email addresses, and it was the job of the FBI field officers to pursue those leads and scrutinize the people behind them. The tips were so frequent and such a waste of time that the field offices reported back in frustration, "You're sending us garbage." So in 48 instances, traditional surveillance warrants obtained from the Foreign Intelligence Surveillance Court were used to obtain evidence through intercepts of phone calls and emails. More than half of the cases were initiated as a result of traditional investigative tools. The most common was a community family tip to the authorities.
So not even their spying. It was a tip.
Yeah. Yeah, they're just getting tips, I guess. So let's see. So the contribution of the NSA's bulk surveillance program to these cases was minimal when finding the terrorists involved in Al Qaeda and 9/11.
And that was their supposed whole rationale for doing it.
Right. So, okay. Yeah. Okay. Yeah, there's no computer that's going to spit out a terrorist name. It's the community being involved in the conversation and being appropriately open to communicating with law enforcement when something awry is identified. So, yeah. Yeah, this looks like that. Yeah, the NSA's surveillance is not very helpful.
Yeah, that's what I have heard before too. Is that
Yes.
it?
All right, and then this is Center for Strategic and International Studies. What privacy in the U.S. looks like without Roe v. Wade. All right, so we're gonna start here. How does Roe v. Wade decision in 1973 relate to constitutional right to privacy? Although the 14th Amendment does not contain the word privacy itself, nor does it appear in the rest of the Constitution, U.S. courts have long acknowledged an individual's right to privacy in home and family life. The Supreme Court first recognized a constitutional right to privacy in Griswold v. Connecticut, a landmark decision that centered around the freedom of individuals to use contraception without interference from the government. The Griswold decision acknowledged the Bill of Rights contained zones of privacy from the government within the First, Third, Fourth, and Fifth Amendments, combined with the Ninth Amendment, which acknowledges the existence of some constitutional rights that are not explicitly mentioned in the Bill of Rights, and the 14th Amendment, which states that the government cannot infringe upon life, liberty, or property without due process of the law. The Supreme Court declared that there is a constitutional right to privacy within the penumbra or shadow of these protections. And we'll go over these amendments a little bit later, what they are. Excuse me. So Griswold set a precedent for numerous privacy-related cases over the past 6 decades, including Roe v. Wade and Planned Parenthood v. Casey. In Roe v. Wade, the Supreme Court held that the 14th Amendment's Due Process Clause protects against state action the right of privacy, including a woman's qualified right to terminate her pregnancy, and that though the state cannot override that right, it has a legitimate interest in protecting both the pregnant woman's health and the potentiality of human life. Striking this balance of interest, Roe v. Wade effectively stopped the enforcement of many state laws that banned abortion between 24 weeks. The Supreme Court later confirmed in Planned Parenthood v. Casey that the fundamental right of privacy protects citizens against governmental intrusion in such intimate family matters, and that a state law would violate the Due Process Clause if it creates an undue burden on a pregnant person's right to choose. So, considering the draft decision, why is it important to also examine data privacy regulations for private businesses? So once Roe v. Wade and Planned Parenthood v. Casey are overturned, it is possible that U.S. private businesses could become either voluntary or involuntary participants in the enforcement of state anti-abortion laws. In particular, numerous popular consumer devices and mobile apps collect an enormous amount of sensitive personal info from users, including precise geolocation, browsing or internet activity, search history, private communications, social media posts, photos, videos, financial transactions, and more, which would allow developers, data aggregators, advertisers, and other third parties to interfere or to infer pregnancy status. In many cases, info may be used for targeted advertisements for pregnancy or baby related products, but more consequentially, it could also facilitate a digital paper trail for law enforcement to compile evidence against individuals who choose to have an abortion. Law enforcement agencies frequently access data held by private companies through a variety of mechanisms, which include legal requests, warrant subpoena court orders, or voluntary sales, dramatically expanding the government's scope and resources to conduct surveillance. Let's see here. Okay. If abortion is outlawed in some states, law enforcement officers can use these same tools to track pregnant people in abortion facilities. Kaiser Family Foundation survey found that nearly a third of female identifying respondents used a smartphone app to track their menstrual cycles, some of which collect and share highly sensitive information about period cycles, sexual activity, and medical conditions. In addition, data aggregators can compile and sell precise geolocation info related to people who visit reproductive health clinics. For example, SafeGraph recently offered local info on individuals who visit Planned Parenthood and other family planning facilities for approximately $160, including the frequency and length of their visits and other movement activity. Even if data brokers take steps to anonymize this data, it can potentially link back to specific individuals when combined with other info. In addition, de-identified location info can still help pinpoint abortion facilities with a high amount of interstate traffic, which may be useful to states such as Missouri that might implement legal penalties for those who facilitate out-of-state abortions, which I don't even know how that's legal because it's not even in your state. How is that your jurisdiction?
Yeah.
But whatever. So, what options might Congress consider in the aftermath of Dobbs v. Jackson, Women's Health Org? In the absence of Roe v. Wade, Congress could theoretically pass a new statute to either permit, limit, or abolish abortion services nationwide, but all these options would be difficult to achieve in current political environment. On May 11th, the Senate voted 51 to 49 against Women's Health Protection Act, a measure that aimed to legalize abortion services nationwide, as well as supersede any state bills or laws that require medically unnecessary in-person services, waiting periods, tests, and other procedures that could delay or prevent abortion services. All right. The vote fell along party lines, with Senator Joe Manchin joining all 50 Republican senators against, and ultimately failed to pick up the 60 votes necessary to overcome a Senate filibuster. While President Biden has supported codifying Roe into law, he also stated that he would not abolish the filibuster to do so. Congress could alternatively establish new guardrails on the enforcement of state laws, including abortion bans, by passing a federal commercial privacy law that regulates how private businesses and nonprofits collect and share personal information. Commercial privacy legislation could indirectly reduce the amount of extraneous surveillance data that government officials might access through the private sector. It is not a substitute for a federal statute that codifies abortion rights nationwide, but is much more politically achievable. Representative Susan Delbane recently advocated for such a bill, stating Democrats must swiftly pass a strong national consumer data privacy standard that protects our personal info, including pregnancy status and other health data. Yes, that's true.
Yeah.
We definitely need to do that. So there is some bipartisan consensus on the basis of federal privacy legislation. Two leading bills in the U.S. Senate Committee on Commerce, the Democrat-sponsored Consumer Online Privacy Rights Act and Republican-sponsored Safe Data Act, both propose to afford U.S. individuals the right to access, delete, correct, and export personal info that private businesses hold, which would grant greater control over sensitive health and location info. Both also introduced the principle of data minimization, which would generally limit websites and apps to only process and share personal info to the extent necessary to provide authorized services. In turn, these individual rights and boundaries on data collection, processing, and sharing could reduce the scale of user info that data brokers and law enforcement agencies can access through either voluntarily voluntary sales or legal requests. So, outside of family planning services, could this decision in Dobbs v. Jackson Women's Health Org more broadly affect privacy or civil rights for individuals in the U.S.? So, the draft majority opinion in Dobbs v. Jackson explicitly rejects the notion that abortion constitutes a protected liberty under the 14th Amendment Due Process Clause. It states that the Due Process Clause only protects rights that are deeply rooted in this nation's history, and implicit in the concept of ordered liberty. I just feel like deeply rooted in this nation's history. I just don't like the way that sounds. Like, I don't know.
It's
It
it's
sounds.
very traditionalist.
Yes, exactly. All right, yeah, and they even said this language has raised concerns. Such an interpretation could threaten the viability of other landmark Supreme Court decisions that, based on similar concepts of liberty and equal protection under the 14th Amendment, established rights that were not available during the American Revolution. What? Okay. Oh, okay. These include Griswold v. Connecticut, the guaranteed right to use contraceptives, Loving v. Virginia, that invalidated state bans on interracial marriage, Lawrence v. Texas, that banned state sodomy laws, and Obergefell v. Hodges, that recognized a constitutional right to same sex marriage. The lead opinion attempts to mitigate such concerns by drawing a distinction between abortion and other fundamental rights, stating that we emphasize that our decision concerns the constitutional right to abortion and no other right, that abortion is different because it destroys what Roe and Casey call potential life, and what the law in Texas regards as the life of an unborn human being. Okay. These assurances are not binding, however, and leave the door open for further erosion of civil rights. It is difficult to state that all rights under the Due Process Clause must be deeply rooted in U.S. history without also subjecting other cases to legal risk. Justice Samuel Alito and Clarence Thomas criticized Obergefell v. Hodges over 20 months ago, writing that the court read a right to same-sex marriage into the 14th Amendment, even though that right is found nowhere in the text. It's implied, though, but okay. And now the leaked opinion casts doubts on the privacy framework that Roe rests on, stating, Roe held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned. As such, the leaked opinion in Dobbs v. Jackson Women's Health Org introduces legitimate concerns over the future of privacy in America, as well as societal impacts that could result from its absence. That's such a stupid argument.
It
First of all,
is.
like,
Their
if you're
argument
the
is
Supreme Court, like,
insane.
you can write new stuff into the Constitution. Like, that's your whole job. Like, your job isn't just to maintain what we have. Like, your job is to
Well,
change
I don't think they can
when you need to. Because
change the Constitution, but they interpret it. But and they should be able to interpret it with an expansive. We've grown as a society and civilization, so
and you
we
can
should have
add
an
new
expanded
amendments.
understanding, huh?
I was saying you can like add new amendments to the Constitution. I mean,
Okay,
that's how
I
it works.
don't. Are you
I mean,
sure?
I don't think you can change an existing amendment unless you add a new amendment that like gets rid of it or something.
One, I think that had to be Congress, though, not the Supreme Court, right?
Is it?
I
Um,
thought so. That would be like that would be concerning to me if the Supreme Court could just write any amendment they wanted. That would be. I wouldn't like that. Because then they could literally add an amendment saying abortion is outlawed, and then that would be part of the Constitution, and that's
Constitution. So, how can the judicial branch change the Constitution? The main task of the Supreme Court is to decide cases that may differ from the U.S. Constitution. Once the Supreme Court makes a decision in a case, it can only be changed by a later Supreme Court decision or by changing or amending the Constitution. Oh, the legislative branch changes the Constitution, though. Okay, you're right.
because don't they have to vote if they want to add an amendment? I'm assuming.
Yes.
I don't even. I feel like it's more of a process though than normal legislation. I would think. I don't know. I guess, but
Yeah.
because is that maybe they have to do that one conference that we talked about the other time. if they want to
Maybe.
change or amend the Constitution. I
Yeah.
don't know.
All right. Now we're going to just look at the Wikipedia for right to privacy in the U.S. Let's read this first part first. The Constitution of the U.S. and United States Bill of Rights do not explicitly include a right to privacy. Currently, no federal law takes a holistic approach to privacy regulation. In the U.S., privacy and associated rights have been determined via court cases, and the protections have been established through laws. We kind of talked about this stuff. Right to privacy has been the justification for decisions involving a wide range of civil liberty cases, including Pierce v. Society of Sisters, which invalidated a successful 1922 Oregon initiative requiring compulsory public education. Roe v. Wade struck down abortion law from Texas and thus restricted state powers to enforce laws against abortion. And Lawrence v. Texas, which struck down a Texas sodomy law and thus eliminated state powers to enforce laws against sodomy. Dobbs v. Jackson's Women's Health Org later overruled Roe v. Wade, in part due to the Supreme Court finding that the right to privacy was not mentioned in the Constitution, leaving the future validity of these decisions uncertain. Why would we? I mean, we just need to add a right to privacy into our Constitution. But getting anything done through the legislative
So
branch,
they don't consider privacy part of liberty?
right? I guess not.
What does liberty mean? If we Google liberty,
Liberty
what
is
is
like freedom. I can Google the actual definition.
okay.
The state of being free within society from oppressive restrictions imposed by authority on one's way of life, behavior, political views. The power or scope to act as one pleases. So those are the two definitions.
I
Which
feel
I
like the
think,
first one would cover privacy.
yeah, I would think violating privacy would be an oppressive restriction.
Yes. Because what is it? It's life, liberty, and the pursuit of happiness. Is that
Yeah,
the saying? Okay. And I'm
yeah,
pretty sure pursuit of happiness would include not having your privacy violated too.
right.
So sure, privacy, the word privacy isn't implicitly or implicitly,
It's not explicitly stated.
explicitly stated in the Constitution,
It
but
is
it's
implicit.
implied. Yeah.
Which, yeah, no, I'll go over that too about all the amendments that implies privacy.
Oh, okay.
So legally, the right to privacy is a basic law which includes the right of persons to be free from unwarranted publicity, unwarranted appropriation of one's personality, publicizing one's private affairs without a legitimate public concern, wrongful intrusion into one's private activities. Let's see. So, in 2018, California set out to create a policy promoting data protection, the first state in the U.S. to pursue such protection. The resulting effort is the California Consumer Privacy Act, reviewed as a critical juncture where the legal definition of what privacy entails from California lawmakers' perspective. The California Consumer Protection Act is a privacy law protecting the residents of California and their personal identifying information. The law enacts regulation over all companies regardless of operational geography, protecting the 6 international acts included in the law. So for the healthcare sector, Privacy Rule of Health Insurance Probability and Accountability Act, Portability and Accountability Act was passed in 96. This safeguards medical data of the patient, which also includes giving individual rights over their health information, like getting a copy of the records and seeking correction. Medical anthropologist Kiara Bridges has argued that the U.S. Medicare system requires so much personal disclosure from pregnant women that they effectively do not have privacy rights. That's pretty sad. But
Well, and also, but how does how do these laws, the laws that they're trying to pass making abortion illegal, not trump like invalidate HIPAA? Don't they?
right,
How does that work? HIPAA and abortion. Like, how is that legal for them, for doctors to report abortions to the state if that breaks HIPAA? How can they do that? That to me would be illegal against HIPAA. Because HIPAA's a legal thing, is it not? Yeah, it's an act. It's a
yeah,
legitimate legal
right.
act. So how can they legally, and why, if anything, us citizens should be concerned if they're allowed to do that, because that, what makes you think they're going to stop? Like, what do you think the government is like? I don't know, it's just odd to me that they think the government is good when they want it to be good, but it's bad when they want it to be bad.
Yeah.
Like, they're like, so they probably would be mad at the fact that the NSA was spying on us, but then they're not mad that doctors can go and report patients' private data to the government. Like, it just doesn't, it's illogical. You
Right.
can't be mad at one thing but not all of it, in my opinion.
Right. So this says the Supreme Court's decision to overturn Roe v. Wade raised concerns that data collected by tech companies and clinics could be used to criminally charge people who seek abortions or lose a pregnancy. So the National Health Data Protection Law, HIPAA, does not cover all types of data that could be used in abortion cases.
Oh.
And then, let's see. So what information isn't protected under HIPAA? It cannot resolve all privacy concerns related to reproductive rights. According to recent guidance published by HHS, the law allows an abortion clinic to disclose who received an abortion in response to a court order or summons, which could become even more common in the post-Roe era. HIPAA only applies to certain types of businesses and professionals. It can regulate only health insurers, healthcare providers, data clearing houses, and business associates. HIPAA can't protect some patient information gathered by anti-abortion organizations, such as so-called crisis pregnancy centers, that attempt to, oh, not the crisis pregnancy centers, those are terrible. Have you heard about those?
I don't think so. Unless you mentioned it last time we talked about
Well,
abortion, but then I forgot.
that's okay. So the crisis pregnancy centers, they basically design themselves to look like abortion clinics, but instead of, they don't provide abortions at all though. They just like try to convince you to still have the child basically.
Oh.
But like they pretend to be abortion clinics. And so people go in there, women go in there for abortions. People go in for abortions, and like they'll just be told like, "Oh yeah, we'll give you the ultrasound," and then they just try to talk them out of the abortion basically.
Mm.
And yeah, they attempt to attract and redirect abortion seekers. And like they can report people too for trying to get abortions, which they would because they're usually run by anti-abortion people.
What a joke.
Yeah. So yeah, I guess that it sounds like they don't consider abortion clinics medical centers,
Yeah, that's weird.
which they definitely should be considered medical centers.
So that would be like Planned Parenthood, right?
Yeah.
That's
Yeah.
weird. That doesn't make sense to me.
Right.
Because they're providing a medical service.
Right. Uh,
Because can't they do STD testing there too?
oh yeah.
So they could, if the government asked them to report their STD testing, they could hand that information over and that wouldn't breach HIPAA.
I guess not.
Ugh, that's,
That's terrible.
that does not sound right.
Right. All right. And then the intentions of the California Consumer Privacy Act. So, the intentions included in the act provide California residents with the right to know what personal data is being collected about them, know whether their personal data is sold or disclosed and to whom, say no to the sale of personal data, access personal data, request a business to delete any personal info about a consumer collected from that consumer, and not be discriminated against for exercising their privacy rights. And then there's mass surveillance. So the government orgs such as the NSA, CIA, and GCHQ, among others, are authorized to conduct mass surveillance throughout other nations in the world. Programs like PRISM, Mystic, and other operations conducted by NATO member states are capable of collecting vast quantity of metadata, internet history, and even actual recordings of phone calls from various countries. Domestic law enforcement at the federal level is conducted by the FBI, so these agencies have never been authorized to collect U.S. data. After September 11th, the NSA turned its surveillance apparatus onto the U.S. and its citizens. So, March 2013, James Clapper testified under oath that the NSA does not wittingly collect data on Americans. Clapper later retracted the statement. The government's own Privacy and Civil Liberties Oversight Board reviewed the confidential security documents and found in 2014 that the program did have a single instance involving a threat to the U.S. in which the program made a concrete difference in counterterrorism or the disruption of a terrorist attack. It had a single one.
Single, yep.
That's real nice. So, okay. And then, according to Cornell law, in Griswold, the Supreme Court found a right to privacy derived from penumbras of other explicitly stated constitutional protections. The court used the personal protections expressly stated in the First, Third, Fourth, Fifth, and Ninth Amendments to find that there is an implied right to privacy in the Constitution. So what are those amendments? Let's go over those. The First Amendment, Congress...
Wait.
Oh, yeah.
You don't, do you mean to be sharing your screen or no?
No.
Oh, okay. Just wanted to make sure.
Yeah, you're good.
Okay, you could keep going then. I just wanted to make sure you didn't think you were sharing your screen.
For sure. No, I just wrote all this down from what
Gotcha. Okay, that works then.
All right. So the First Amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So yeah, that's basically freedom of religion, freedom of speech, freedom of the press, freedom of association, and right to assemble, all that good stuff. So the Third Amendment, no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by the law. So that basically means that, like, a citizen can't be forced to house soldiers.
Yeah.
And then the Fourth Amendment, the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So basically, no one can search your property without a warrant or probable cause. And then the Fifth Amendment, nobody shall be compelled in any criminal case to be a witness against himself. So an individual can't be compelled by the government to provide incriminating evidence against themselves. So, like, in court, they can't just ask you, like, did you do the murder? You know?
Yeah.
Then that would be incriminating yourself. So the Ninth Amendment, all the rights not listed in the Constitution belong to the people, not the government. So the rights of the people are not limited to just the rights in the Constitution.
Read that one again.
So all of the rights not listed in the Constitution belong to the people, not the government. So it's saying that the rights of people are not limited to the rights that are in the Constitution.
Okay, yeah.
Which the Supreme Court seems to love ignoring.
Yeah, that's
pretty unconstitutional of them, but whatever.
Yeah, any laws taking away rights, even the trans laws,
right,
are going against the Constitution. The Don't Say Gay bill, that goes against the Constitution.
100%.
All these do. Gay marriage, laws restricting that, goes against the Constitution.
Yeah.
With that, I wasn't aware of that amendment, I guess, because that's an amendment, right?
Yeah, that's the Ninth Amendment. Yep, I wasn't aware of
They
it.
don't want to share that one. They don't want us aware of that one.
Yeah, they don't want you to know about that. But yeah, that's everything I had for this.
Okay.
So I don't know if you have anything you wanted to talk about, but
nothing. Just I find it again hypocritical that I feel the people who argue for Roe v. Wade being overturned, who argue against privacy, would then argue against the government spying on us. But to
Yeah.
me, that's hypocritical. Because
Yeah.
what is that saying? You don't get cake. You don't get your cake and get to eat it too. Is that how it goes?
Yeah. Yeah. You can't have your cake and eat it too.
Can't have your cake and eat it too. Because you can't look, if you are fine with them overturning Roe v. Wade and privacy being overturned, then you have to be fine with all privacy violations. Otherwise, you're just hypocritical. Because there's no, I mean, the only argument they're going to come with is that, well, it's a life. No, it's not a life until it's out.
Right.
It's
It's not sentient for a very long time.
And you have no right to know if someone's pregnant, anyways. That's someone's
Right.
privacy. You don't need to know if someone's pregnant. So, the only reason you know that people are pregnant and getting abortions is because you're sitting outside abortion clinics. If you wouldn't
Yeah.
sit outside abortion clinics, you wouldn't know.
Right. Yeah. And like, yeah, it's just, yeah. Oh, this I mean, for one, abortion is a medical
Yeah.
procedure. So it should be definitely included under HIPAA. I don't know why it's not.
Yeah, I
There
wonder if
should
they
be,
go to like an actual doctor and not Planned Parenthood. Not that Planned
right,
Parenthood aren't doctors, but just if they go to like an actual doctor's clinic to get an
right,
abortion and not Planned Parenthood, then if it but I'm
right,
assuming the government would still tell that doctor they have to. I mean, doctors technically, with those laws, can't even perform abortions, or else they're gonna become felons, which is also crazy
right.
because with our
And
healthcare system in shambles, let's felonize doctors. Why not?
yeah,
What do we
let's
got
just,
to lose?
right. I mean, I don't know. I guess sometimes you just gotta hate the doctors. The people saving lives every day. You just gotta make their lives a million times worse.
Oh, do these?
Like,
Hmm.
how can you villainize a doctor? Unless it's
I,
like, like eugenicist or something. But I mean, that's not
yeah,
the case here.
no, they're just literally performing a medical procedure at
Right.
the request of the patient for the betterment of the patient.
Yes.
But then some people decided that that is wrong,
Yeah.
which blows my mind because there are so many other things we could be standing against, but this is the battle you're choosing to fight.
Right.
Really. Well, whatever. I guess when we lose all of our privacy rights, we'll know who to blame, right?
Yeah.
Because it's like a domino effect, I would say, kind of.
Yes.
I mean, I hope not, but I guess I feel I like to have hope, I guess. So I think all this will be overturned again in a good way. I
Hmm.
think it's because people again will. I think a part of it's also coming down to knowledge and education and just information and understanding. I
Yeah.
guess too that what these people are trying to scare you with, these fear tactics, aren't actually happening. And
Right.
what is it? Moral panic, and yeah, they're
Yeah.
just trying to push moral panic too, and that only can last for so long before people. I would hope people start to wake up and be like, well, maybe let me question what I've been told, as we should all the time,
Yes.
anyways. But yeah, so I think it's just important to be aware of privacy and privacy that we're losing too,
Yeah.
and just we'll keep fighting for privacy. I would say as
Yes.
citizens because it's our right, and like it says in the Ninth Amendment, it is our right, even if it's not explicitly stated, it is implied in the Constitution that that is our right as citizens.
Hmm.
We deserve that right. It's guaranteed to us.
Yeah.
But otherwise, you guys can leave a comment below letting us know what you want us to talk about in future episodes.
You can reach out to us on Facebook, YouTube, Instagram, Twitter, and TikTok, and we do occasionally do Twitch live streams.
Yes, so don't forget to like, follow, and turn on notifications so you know when we do. Otherwise, we will see everyone next time.